Thank you, Ben, and good afternoon, everyone. I am Professor Victoria Baines, Professor of IT at Gresham College in the City of London, where my responsibility is public engagement on issues of technology policy, IT policy, including online safety. So it remains for us to ask in this session, to which you are very welcome, what are the latest developments in digital safeguarding? And what are governments and tech companies doing in this space? And how can we all ensure that we achieve the right balance with other digital rights? Well, I'm very pleased to say that I have a stellar panel of experts joining me to help answer this question and to explore some of these issues. We have Andrew Carroll, who is Assistant Commissioner for the Iris Data Protection Commission, Thomas van der Valk, who is Privacy Policy Manager for Europe, Middle East and Africa at Meta, Joey Conway, who is partner at Deloitte Legal, and advocate Collen, who is Commissioner for the South African Information Regulator. A very warm welcome to you all. We're going to set the scene first, if that's okay, to give people a bit of background and get them up to speed on what's going on in the environment. So firstly to you, Thomas, if that's okay. What's going on in terms of regulation, but also in terms of what companies are doing to make the online space safer? And what are the key areas where digital safeguarding is particularly notable?
Sure, thanks, Victoria, and thanks for having me on the panel. So I think there's a lot going on in terms of regulation around youth. Also, Meta is investing a lot in this space in making sure that all users, but particularly youth, are protected on our services. So if we want people to connect with each other across the globe, people need to feel safe in doing so and using our services. So we are heavily invested in getting that right, but that is definitely a challenge. So I also want to state that for young people, it is also incredibly important to be able to go online in safe environments in order to educate themselves, in order to develop themselves, and to access the right resources and services that they need in a responsible way, of course. At the same time, we need to safeguard their safety and with lots of things in life and in tech, and nothing is straightforward. So there are no single perfect solutions to getting to the right balance between, for instance, safety and privacy, etc. That's why we've been working on a multi-layered approach where it comes to safeguarding, particularly minors. So that involves age verification, parental supervision, and also an age-appropriate experience. And we have a whole suite of tools and safeguards that do just that. So you can think of privacy settings, of safety tools, particularly aimed to protect minors, messaging controls, tools for people, including minors, to report violating content, anti-bullying tools, but also ads restrictions for minors, which has also been included by the recently adopted Digital Services Act in the EU. And we've invested a lot in educational resources for minors and their parents. So this year, for instance, on Instagram, we've launched the Family Center, which provides tools for parental supervision and also resources for teens and adults to make sure that the right tools are in place and that the conversation between teens and adults and parents and their guardians is facilitated. And of course, there's the online safety bill in the UK and COSA in the US being discussed as well. And also here, we think this issue is so important that we support any measures that keep young people safe. Of course, we also have our own insights on this, and we continue to work with regulators, policymakers, and experts alike on this, and especially also teens and adults, because we need to solve these issues together. We can't do that in isolation. So I think I'll stop there.
Thanks, Thomas. And I think you've touched on a number of themes that I think we're going to dig into a little bit later in the session: age verification, parental resources, educational resources, and age-appropriate content and spaces among them. But Joey, I'm going to move to you now, if that's okay, from the legal overview. What are you seeing happen from a regulatory perspective?
Yeah, no, thank you. And just to echo, I completely agree with what Thomas has said about this being a multi-layered issue, and it does require different stakeholders to play their part. And there is a range of measures that are important here, from laws and regulation, which I can talk to, but also things like education, media literacy, the tools you put in place to empower your users, parental controls, all those things, great things that Thomas talked about. But from a legal and regulatory perspective, what we're seeing, and the way we characterize it at Deloitte, is we're seeing actually a wave of regulation and laws coming in globally, which touch on this issue of making the online space safer. A lot of that is principles-based regulation, and actually the GDPR and the approach to personal data is a good analogy. We've seen developments in that space over the years. We've learned from that, and we're now seeing similar regulation coming in, but tackling other issues that are relevant to safety. Privacy obviously is one of those, but we're seeing regulations around online content, for instance, around interoperability and security, all those different things. We're seeing this regulation coming in. So what we're seeing is a new layer of obligations being put on predominantly on the platform companies. We've always had laws and regulations that apply in this space. So a user posting harmful or illegal content that harms another user, there will be potential laws, depending on the jurisdiction, which enable that user who's been harmed to take action against that user who's harmed them. And there's also generally a principle of that platform who's hosting that content potentially being liable for it, depending on shields that are in place, etc. That's still there, and that's always played a part in online safety. But now, with these principle-based regulations coming in, we're seeing these obligations on platforms themselves to say, you need to be responsible, you need to risk assess, for instance, illegal content, and then you need to take mitigating measures to prevent the harms. And that's new, that's different, and it's an extra additional layer that's going towards making the online space safer.
Thanks, Joey. Yeah, I mean, this is something that in my analysis, I've certainly seen as being the new ask. We've moved on, haven't we, from a world in which notice and takedown was deemed to be sufficient, and where there is a more proactive role in creating safer environments, be that by content regulation or by ensuring a certain level of privacy. And I think we'll dig into the need to balance those rights a little bit later in the session. But I'm going to take a couple of national perspectives now. So Collen, you're on the sharp end, if you like, of operationalizing online safety at a national level and thinking about regulation, but also how you achieve online safety practically. I'd love to hear your perspective on what you think the key issues are now.
Thank you so much. And yes, I do agree with my fellow panel members. What the UNICEF report found is that 95% of children in South Africa have access to the internet, and 1/3 of those 95% are actually at risk of experiencing violence, exploitation, etc. So that then underpins the type of exposure and risk that children in South Africa are exposed to from an online perspective. So what is very important is that we've got a Cybercrimes Act that came into force or into effect in 2020, but it does not provide for the full extent of protection, specifically of children, but it more or less provides a broad landscape that is all inclusive, and it is not yet being tested fully. But I also do agree that various stakeholders do have to play a role. But what I think is very important is that we need to, at some stage, analyze through a grid of stakeholders the extent to which each stakeholder influence is required to ensure online safety. Just by way of an example, South African Information Regulator had a discussion with TikTok, and it was then just an preliminary education of the information regulator about the type of measures that they're putting in place to ensure the safety of children when they do use TikTok. But during the presentation, the chairperson and the commissioners made various critique, which TikTok has subsequently taken back to ensure that these measures that they are putting in place are more enhanced and very responsive. But as technology progresses, there will always be that gap, but the monitoring part becomes critical in this instance. Thank you.
Thank you, Collen. And I think that's a really interesting point, that the needs of children and young people or of users in different markets may not respond to a one-size-fits-all provision of online safety, and that going out and speaking to regulators in different countries means that you can actually make platforms safer as a whole by incorporating some of those different needs and getting that tailored feedback from those markets themselves. So thank you for that. And this is where I think we'll bring Andrew in, because we've been talking about children and young people as being one of the target groups of online safety initiatives. So Andrew, I know you've been working on that very, very closely. If we're thinking about some of the most heinous behaviours to which children might be subjected on the internet, things like child sexual exploitation and abuse, which universally, all countries and all platforms have outlawed. It's one thing operationalising that on its own, isn't it? But how do we achieve a balance between privacy and data protection and ensuring that we deliver safety for children and young people? What are some of the challenges attached to that for you?
Thanks very much for your question, Vicky, and thanks also. I just want to echo the points that everyone else made, which I fully agree with, and also thanks very much for the invitation to speak on this panel today. So in relation to your question, obviously this is a very complex issue with very valid concerns being raised on both the privacy and safety sides of the debate. So it's important to recognize first and foremost that there is a trade-off between individual privacy and safety, because in my experience, this often isn't acknowledged enough. So the more absolutist approach that we adopt to upholding individual privacy rights in all circumstances, the less safe the most vulnerable users, such as children, will be, because that will entail, by implication, respecting the privacy rights even of individuals suspected of creating and sharing CSAM content. But on the other hand, it is an open question as to how much of our privacy and anonymity we are collectively willing to give up to keep children safe. So I'm sure our audience will be aware of the various legislative proposals in the UK and the EU, which would, among other things, create significant new monitoring obligations on providers of end-to-end encrypted messaging services, which have raised understandable anxieties about the long-term consequences for individual privacy and whether this is the thin end of the wedge and what the consequences will be for freedom of speech and freedom of information rights and others. Because if we bring in these rules for detecting CSAM content, then maybe one day we will expand them to fighting other online harms, such as extremist content or content that incites violence or content which encourages self-harm or suicide. So these are understandable concerns, and they illustrate the complexity of the rights balancing exercises that are required for regulation in this area. And we also have to think of the risk of so-called false positives and the potentially extremely damaging consequences for individuals who are wrongly flagged as having shared CSAM on social media or information society services. I'm sure everyone will have seen that article recently about the father whose account with a major online platform was wrongly suspended because he was sharing pictures of his infant son with his doctor to try and get a medical concern diagnosed. So this is just an example of the complexity of the issues that we are all grappling with. But I suppose from my perspective, it's clear that the status quo is not an option, because the prevalence of this sort of harmful content it's a large scale problem which can't be ignored. I believe in 2021, the National Centre for Missing and Exploited Children received about 30 million reports of online exploitation of children per year, almost all of which came from self-reporting by the large online service providers. So it's clear that we can't turn a blind eye to this. We need regulation in this area, and that regulation will involve difficult decisions and trade-offs. Data protection law in Europe, the GDPR, is clear that the right to data protection should be considered in relation to its function in society and balanced against other fundamental rights and freedoms. And that presumably includes the rights of children to be free from all forms of physical and mental violence, as per Article 19 of the UN Convention of the Rights of the Child. So in terms of how we manage these trade-offs, I think we need to embrace and encourage innovative solutions, including artificial intelligence for detecting and removing CSAM from social media platforms. We need a diversified toolkit, but we need to make sure that all of these tools are designed in full compliance with data protection law, such as, the principles related to the processing of personal data, which everyone knows, relating to lawful fairness and transparency, purpose limitations, storage limitations, security. We also need transparency around these tools so that we know that they are effective, that they are doing their job and detecting and removing CSAM content, but also transparency in terms of how they are designed so that we know that the necessary rights balancing exercise have been carried out, and that any threats to individual rights and freedoms have been identified and mitigated as far as possible. And we also need better education and public awareness around these tools. So in the European context, it's good to see legislation being tabled, with the European Commission's regulatory proposal for detecting and monitoring CSAM unveiled earlier this year. It's now received a number of submissions, including an opinion from the European Data Protection Board. And it's for the institutions of the European Union, the lawmaking institutions, to now further develop and refine those proposals, taking into account all the feedback that they have received, which will bring much needed clarity for everyone operating in the digital space as to where the line falls between these two objectives. So these issues are complex, and it's entirely right and proper that they are with the lawmaking authorities now at European level to give clarity for all stakeholders. That's everything I have to say on that point.
Andrew, thank you very much, and lots of food for thought that I will try and pick up on in turning to the other panelists. So I'm a great fan of a whole society approach to some of these issues that may have been exacerbated by use of technology and greater connectivity, but still have their roots in society. So if we take an example like child sexual exploitation and abuse, offenders will misuse that technology, but we still have a certain proportion of the adult male population that has a sexual interest in children. So even if we put technical barriers in their way, we've still got a demand problem. So I'm a great fan of thinking about how we can strengthen other aspects of society and not just look for a technological silver bullet. So with that in mind, Thomas, you touched on educational initiatives. Joey, you mentioned about this being a multi-layered problem that requires multi-layered approaches. And I wondered if any of you would like to add on educational initiatives that you think are particularly good, what's needed, and also thinking about the creation of age-appropriate spaces, where we stand at the moment on age verification, how that might differ from age assurance, and how we might balance the need to identify people's ages or be assured or verify people's ages with the need to also protect their privacy and their data. So if any of you would like to jump in there and volunteer. Thomas, go for it. Thank you.
Sure. Thank you, Victoria. So to build on what Andrew said about the problem of child sexual abuse and the current proposal of the European Commission, I think platforms have a gigantic role to play here. This is such a terrible crime. Platforms need to live up to their responsibility, and it's a good thing that the European Commission is putting something on the table. However, as you say, Victoria, this is also a societal problem, and it cannot just be solved by a detection-only approach, right? So, of course, detection is an important element of fighting the distribution of CSAM. However, we have been investing much more in a much wider approach, for instance, by investing heavily in prevention of abuse taking place in the first place, and making sure that harm doesn't happen in the first place. So an example of this is using communications metadata to see whether, for instance, adults who also have a slightly suspicious profile are reaching out to minors that they don't know, for instance, at a high frequency. So those are indications that are not about accessing content to detect CSAM as such, but that can still help a lot in making sure that we send either a safety notice to teens about the fact that there is someone reaching out and they may want to reconsider whether they want to open that message, for example, and we've been sending out millions of those safety notices, or that we restrict the ability of these adults to reach out to minors, again, in order to prevent harm from happening in the first place. So this is really an emerging area, and we believe that the European Commission, with their proposal, are not sufficiently focusing on these use cases. And for this, we would need to have access to communications metadata, preferably in an express legal basis, so that companies can evolve with the threats, because these threats evolve. Offenders find new ways of conducting malicious behavior, and we need to have the legal certainty of knowing with which a legal basis and safeguards we need to build. And also to the point that Andrew raised about the importance of safeguards. Redress is incredibly important, and we need to get that right, and transparency as well, so that you don't get very negative effects of false positives, for instance. So I think there's a lot of work to be done on the CSAM regulation still to get it right. A detection-only approach is not sufficient enough, but also risk, especially when messaging services are encrypted, of undermining encryption and the safety that comes with encryption, also for teens and minors. Well, I have to say teens who use messaging services.
Thinking about a case study of the fathers mistakenly reported or reported unjustifiably to law enforcement. I mean, it seems to me that there are sometimes unreasonable expectations of tooling and of artificial intelligence that neglect the need for analysis in context, of understanding the reasons why people might be engaging in certain behaviors, recognizing that, you know, sharing CSAM is illegal the world over, or in you know, most countries in the world, and is an absolute serious crime in itself. But equally, when we're thinking about the regulations in development in the EU, including the Digital Services Act, transparency is the watchword there, isn't it? It's about telling people, telling users, and telling national contact points exactly what has been done, what tools are being used to identify, flag, and remove content. And I wondered, I'm going to go back to you, Thomas, but you know, feel free, anybody, to jump in if you see any challenges in the level of transparency being requested there.
Transparency is incredibly important, especially when it's about you know, the reporting to law enforcement that can have such heavy impact on an individual's life. So of course, their transparency should definitely be on top of the list of the safeguards. Perhaps when you talk about more soft actions, like restricting the ability of someone to reach out to minors, you could wonder whether it is helpful to then notify the user concerned that this has happened, because that might lead them to game the system basically and to find other ways. So I think there's still a discussion to have of what level of transparency is appropriate there. Should it be at an individual level or more at a general level, for instance, somewhere in the policy or terms of service, for example?
So I think that may chime with perhaps a law enforcement assessment, and I only say this as a former law enforcement officer myself, but that your persistent will find workarounds, whatever security measures and whatever regulations you put in place to prohibit them from engaging in a particular form of activity. Joanna, your thoughts on transparency and the drive towards that in regulation at the moment?
Yeah, just one point, because we've picked up on the need to balance fundamental rights, so privacy against the rights of a child being a key one, and there are obviously others in the context of safeguarding. But the example that's been given of the father and the child, that's obviously must have been terribly distressing. But it's really important to understand that if a platform's using AI because of the sheer volume of content it needs to detect and analyze, sometimes it will get it wrong. And there's a balance that's required there as well, in the sense of, okay, so occasionally it gets it wrong. What does it need to then do to correct things? But also, how much is it getting right? And should we be so critical of the tool that's there? Are we actually better off overall for having the tool? And I think that's what the regulations are going to be good at, in the sense that if you look at the DSA or the Online Safety Bill, they require a kind of a holistic risk assessment, and then a look at what mitigation you've put in place, an assessment of how effective it is. That doesn't mean it's going to be perfect, and we will have to face trade-offs around it. So that's just a sort of a point. And then around transparency, etc. Yeah, I think that's another part of the toolkit here, and Thomas has talked about it and others have talked about it. This, again, it's that multi-layered approach. Yes, we've got laws and regulations, not just the regulations coming for the platforms, but also, for example, requirements to report to law enforcement about serious crimes. That's going to come in and be crystallized into law now. That's important. So we're going to have law enforcement proper looking at this as well. But also, yes, transparency, educating users, and that includes educating potential victims, but also your point, Vic, about society. Do we need to be better at educating everybody out there about what isn't acceptable online in the way that we do perhaps better in the physical world? We just don't quite know how to do it in the digital world yet. So yeah, transparency is critical. Media literacy, training that's given, and I know there's a lot of training in schools, for instance, to children to teach them what is and isn't safe online. That's something which is new, and it'd be really interesting to see the impact that has on this generation coming through. They are a lot more savvy and hopefully a bit more protected. But maybe we're not doing enough in terms of actually talking to society about what is and isn't acceptable. This is our world. We're creating a digital world, and we need to be strong about what we want that to look like. User empowerment, I think, is also really important, and the measures we've talked about already have an emphasis on that. So, giving people the tools to either report or to protect themselves. And the Online Safety Bill certainly got something interesting there around user verification. So the principle would be, for instance, that if I didn't want to be contacted by somebody who hadn't verified their identity, then I would be able to select that as an option. Now, there's pros and cons around that, and whether it's right or not, we could have a whole other debate about it. But it's an example of, there are tools that you can give to users to protect themselves as well. So yeah, I think transparency is important, but there's a whole host of other things that need to be considered as well.
Thanks, Joey. I'm going to take your phrase holistic response, holistic approach. And Collen, you've been listening very patiently and very intently. How does that whole society response play out for you in South Africa?
Yes, thank you so much. So I just want to confirm that in South Africa, it's quite a complex issue because our society consists of a lot of different races and different belief systems. And what you could consider as harmful in one race is not necessarily the case in another. And there's a lot of gray areas and there's a lot of differences of opinion. But what I can say about our holistic approach in South Africa is that it's not really yet structured. The police are not yet educated to the level where they understand online sort of like crimes or cyber crimes. But what is also very concerning is that parents themselves, due to potentially high level of yeah, illiteracy, also has that gap. And you found that most parents are not tech savvy. So the holistic approach might not succeed in a South African context due to a lot of issues that societal or gaps in that approach. But just to touch on one of the aspects that Thomas related, for instance, is the fact that if, for instance, part of the tools and the instruments is when, for instance, one user reaches out to a lot of children. I studied digital forensics, so what I would do if I'm, trying to get under the threshold is to set up a lot of profiles and accounts and then reach out once. So then I come in below the threshold. So for us, what is very important is what Joanna said about the starting point of user account verification that is so critical. But again, it is so much of a problem that there's gaps because there's also the commercialization aspect where a lot of accounts also is profitable for a social media organization. So the intensity of verifying a specific account is not at a desired level. And what is also very important is that I know of a lot of people that complained. For instance, Elon Musk had a problem with his Twitter offering by stating that there's a lot of accounts that are not verifiable or false accounts. So that in itself is a concern, and that in itself should trigger a more holistic investigation and a continuous verification of accounts. But once you verified, I'm not too sure, and maybe Thomas knows that when there's a suspicion about your account, it should trigger some sort of a suspension and automatic re-verification of that user account to a certain extent, which I don't think is quite coming through at the moment. But there's a lot of gaps in the system, and I say that in South Africa it's even more complex because of the social context that we find ourselves in. Thank you.
And Collen, you've taken us into a really interesting space. We've kind of moving slightly on from children and young people into wider aspects of the protection that we can do adults and what should expect of safety. Before I jump, is there anything else that you wanted to add to that discussion around children and young people?
Thanks, Victoria. I'm very happy to lead us on to the next topic about the role of parents, because our position is that parents have a hugely important role as guardians of their children's data protection rights, particularly in the digital environment. In our experience, there tends to be a general misconception that children don't have all the same data protection rights as adults, but this is obviously not the case because children are data subjects in their own right and enjoy rights in relation to their data at any age. So the status of children as individual rights holders is reflected in the text of the Convention of the Rights of the Child, which recognizes the particular responsibilities and duties that parents have in relation to their children, but which also says that they must be consistent with the evolving capacities of the child. And this means in practice that the younger a child is and the more vulnerable they are, the more likely it is that the parent will act on their behalf. But as the child grows and develops and interacts directly with the digital environment, then parents should transition into a supporting and advisory role that might involve talking with their child about data protection and online safety issues and leading discussions, also working with their children to help them exercise their data protection rights, because even if children are rights holders, they will often expect and want their parents to help them make access and raise your requests, etc. And also being ready to intervene when parents are concerned that their child is being exposed to an online harm or a risk of their personal data of some kind. So this is the first thing that we have to bear in mind when we discuss the role of parents in relation to keeping children's data safe online. Another important consideration is the distinction between parents and legal guardians, because although most parents are legal guardians, not all are, and conversely, not all legal guardians are parents. And these considerations, they illustrate the complexity of this issue and the difficulty in making general statements about the role of parents or concerned adults in the family circle, particularly when it comes to exercising data protection rights. We also need to bear in mind that in a minority of cases, and this touches to a certain extent to the earlier discussion on CSAM, but in a minority of cases, threats to the child can come from inside the family circle. As I believe Dr. Sonia Livingstone has noted, we tend to frame threats to children purely in terms of stranger danger, but there is a risk this overlooks the risk to children that can come from within their own circle of trust. And this is also acknowledged in the text of the Convention, General Comment number 25 on the Convention, which states that forms of digitally facilitated violence and sexual exploitation and abuse may also be perpetrated within a child's circle of trust. So it's also important that we also have to remember finally that not all children have access to parents or legal guardians at all. And so we need to consider the needs of vulnerable children, children in the care of the state or in temporary care, or refugee and migrant children. So all of these children have an equal right to have access to online services that are designed with their safety in mind, and that are designed to facilitate their other rights under the convention. So while the role of parents is crucially important, it's very important also to ensure that any debate on safeguarding children does not exclude the most vulnerable children who have an equal right to these services. So what that means is parental empowerment and supervision tools are an important piece of the puzzle, but they have their own blind spots, and we must design protections so that they are complementary and not relying on one approach to the exclusion of all others. So our position, as outlined in our guidance on data protection rights, is that, again, children are rights holders, but parents have a rebuttable presumption that they are always acting in the best interest of their child, except where there is evidence to the contrary. And what this ultimately means is that it's for the online service providers to decide on a case-by-case basis when a parent is stepping into the shoes of their child and trying to exercise their data protection rights, taking into account all the relevant contextual factors, whether it is in the best interest of the child to let that parent to grant that parent access to that child's data or to exercise their rights. So parents have a hugely important role as custodians of children's rights and as a source of assistance and support. And this means that they should have access to parental supervision tools and dedicated information resources to help them help their children. But this is a very this is also an area where everyone potentially has a role to play. But when defining the role that parents have in safeguarding children online, we must be careful not to exclude vulnerable categories of children, or to place too much responsibility on parents, because the services themselves have to be safe. Now, I just like to finally caveat all this by saying that for any parents who are concerned that they're stepping on the toes of their children, you have to distinguish between parenting issues and broader online safety issues. Children have their own data protection rights, but parents are more than entitled to set rules about what goes on under their own roof. So it's simply about bearing in mind that your child's data belongs to that child alone. And when you're exercising that child's data protection rights, asking yourself, am I doing that in my child's best interests? And if you keep that in mind, then there's unlikely to be any problem.
Andrew, you and I think we could talk about this for many, many hours, particularly in the light of parental tools and safety programs as instruments of control, particularly where children have a right to freedom of expression, but also freedom to explore their sexuality in safety, that kind of thing. I think it's a fascinating conversation, but we're just, for the last few minutes, if that's okay, we're going to take it into the space of what in the online safety bill was originally framed as legal but harmful. So taking it also out of the adult space that Collen was talking about. When we're looking at adverse experiences and unwanted behaviors or unacceptable behaviors that don't necessarily meet the threshold of criminal, but are, as termed by some of the tech media, awful but lawful. Who's responsible for policing those? Who's responsible for preventing those? And is that slightly different to the response expect criminal offences, and also to protection measures for children and young people? Would anybody like to take that one? Thomas, you look like you're going to speak, so I'm going to pounce on you.
Thanks, Victoria. I think here the key word is control, giving teams control over their experience and to be able to block or report individuals that they think are harassing them, for instance, even though it's not harmful behavior, but like undesired behavior rather than really like illegal, basically. So that either way that teens have the tools to have the experience that they want and need, and also to echo Andrew's point around parental supervision. It's very important that both the teens and the adults, the guardians or parents, consent to these mechanisms so that it really works for the protection of the teen, and that it really incentivizes a healthy conversation around the use of social media, so that the parents, who have a very important role to play, can talk to their teens about also unwanted behavior that may not be illegal, right? So that you stimulate that kind of conversation. And again, Victoria, you already mentioned the importance of education pieces. I already mentioned the family center that we launched on Instagram that provides tools for parents to have conversations with their teens around social media use and the different types of behavior they may be able to encounter.
And Joey, I'm going to give the final word to you, if that's all right, mindful of the time, and also conscious that you've probably gone through all of the developing regulations and the drafts with a fine-tooth comb. We conducted a bit of research with YouGov, asking people who they would report certain crimes to that they experienced online, and we found that just 50% of UK adults sampled said that they would report hacking to the police. Most of them would actually report to the platform on which it happened. So going back to your multi-layered approach, what do you think a response looks like to adverse experiences experienced by adults online?
Yeah, I think that's really interesting, and it's certainly, there's a lot of evidence and data out there around, again, the sheer volume of data online, and even really serious issues like CSAM. The truth is that law enforcement does not have the resources to deal with it all. So we have to be kind of realistic about that. So it doesn't surprise me that people aren't reporting all hacking, for instance. And also, if they did, I suspect law enforcement would be completely overwhelmed and wouldn't be able to deal with it. So interesting. I think on harmful content, both the DSA and the online safety bill look at harmful content. They look at it in different ways. The online safety bill is coming for a lot of criticism around it, and we're obviously waiting to hear what happens around those particular provisions. But actually, if you do analyse what those provisions are in the draft that's public at the moment, they are relatively narrow, and really they are targeted at empowering adults rather than putting a whole load of things that obligations on platforms, etc. So it is treated very differently. And I think that empowerment point is one of those tools in the toolkit that we've talked about. So empowerment, transparency, reporting, all those things go together. So the online safety bill, I think it's been overblown, overstated as to exactly what it does around harmful content. Who should be responsible for for harmful content and the sort of awful but lawful. I mean, we are seeing digital laws coming in now to make things illegal which weren't already. So we do need to be a little bit careful that things that are harmful are somehow less serious or less egregious. I mean, there's a lot of stuff out there that could cause, you know, when we say harmful, it really is harmful. It just may not happen to be illegal under laws we have at the moment because they are all crafted for the physical world. So I think it's a balance. I think it's up to policymakers and society as a whole really to set those standards and say what is acceptable and what isn't. And that's obviously developing thinking. What I do worry a bit about is putting all of that responsibility onto platforms. You know, if we as a society and as policymakers and lawmakers cannot make that call and say, no, this is and this isn't acceptable, why do we think the platforms will be able to do that? And do we really want them to be the arbiters of it? So I do think that maybe there's more that could be done around it.
Thanks, Joey. Well, you heard it here first. I think we have the ideal recipe for this response. Now all we need to do is go and put it into practice as a group of 5 people globally. So it's a holistic, multi-stakeholder response in which users are empowered and in which there is transparency. I think I've captured most of the points there, but with that, I'm going to thank Andrew, Collen, Joey and Thomas for their contributions. That was a fantastic discussion. And I'm going to hand back to Ben and the team. Thank you very much.